Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. Today we are talking all about indemnifications. Indemnifications in dealmaking is sometimes, I think, a bit intimidating because people don't understand what it means and they feel like that's the lawyer's jargon. But if you're looking to increase your deal-making skills, whether you are buying or selling a business, you have to understand what an indemnification does, what the typical negotiations are going to be around it, and how it impacts your deal. Because while your attorney is working in your favor, so much of deal making is risk allocation and understanding what risks you can live with and what risks you can't live with. Certainly, we don't want to leave you underprotected, but it's also important for you to really understand what level of risk you're comfortable with and then communicate that to your attorney so that they can best represent you in the negotiation of the indemnification. So while this is a very heavy legal topic, it's something that I'm sure you can pick up pretty quickly and easily. And I think it's going to help you tremendously in really understanding deal making as a whole. With that said, let's talk about a few things. First, I have to have a little laugh because Miss Molly, who's my dog and one of my golden retrievers, she chewed up my notes for today. So we can all have a little laugh about that together. Yes, Molly, that's you. You want to come here, Molly? Come show your face. Come show your face. Oh, yes. Was this you who ate this? It's a typical case of dog ate your homework, except in this case, it's dog ate your show notes. Do you have anything to add about indemnification, baskets, caps, reps and warranty insurance, all the things? She is a rock in our team. And by the way, before we get started, let me also grab my new book. If you have not pre-ordered it already, you absolutely should. Join the wait list, get the first chapter and everything. Let me grab that for you. This is my new book, Entrepreneurship Through Acquisition, a legal guide to buying a small business. So if you're on the buy side or a seller who wants to know more about what buyers are thinking about, this is a phenomenal resource for you. We talk all about different material deal terms, including indemnifications in this book. And be sure to grab the first chapter. It's linked in the show notes. I'm really, really excited to share this with you. It has so many good teachings, lessons, all micro lessons, things that are easy to understand and pick up, just like this episode will be. With that said, let's talk a little bit more. What is an indemnification? An indemnification is solely a provision that will shift the risk between the parties for claims. And you can define that in any way you want. The thing that I love about contracts is that everything is negotiable. So it's whatever the parties agree upon. And when you're thinking about indemnification, sure, you can think about it from buy side or sell side and however you're negotiating it and what your position is. But most of the time in an indemnification provision negotiation, be prepared to receive what you give. So, kind of that golden rule, treat others how you wish to be treated, indemnification, that prevails. So when you're asking for a certain level of risk protection, expect for it to be asked back to you. So if you don't want to go somewhere, don't ask for it. But on the whole, most indemnification provisions end up pretty fair between the parties. There may be some outlying reasons. Perhaps there's an existing lawsuit or something that may be exceptions, but on the whole, they tend to be pretty evenly sided. And so while they are super important to negotiate, it's not necessarily where you're going to win the biggest battles, and it's not really intended to be that way anyways. When you're talking about risk between the parties, it's intended to be pretty fair what that is. So an indemnification is a contractual obligation for one party to compensate or cover the other party in the event of certain losses or liabilities. And so on the whole, what you would generally expect is that if something occurs pre-closing, the seller is responsible for it. If something happens post-closing, the buyer is responsible for it. On the whole, that's pretty much expected by most parties. Now, sellers may try to get out of responsibility for pre-closing, and buyer may try to get out of responsibility post-closing, sure. But on the whole, that's what you kind of expect. But with that said, there are a lot of nuances which make these complex, challenging to negotiate, and something that lawyers love to go back and forth on. For me, I always think it's pretty simple, but some lawyers really love to dig into this. So with respect to what it does for the parties, it is going to protect the buyer from post-closing liabilities that may have occurred from something that the seller did pre-closing. With a business, this is super important. You do see this to a certain extent with real estate, but not as much as you see it with a business. And then it's also going to make sure that the sellers don't feel like they are on the hook forever for all of these things. And of course, it also provides like a nice mechanism for dispute resolution and having financial recourse, which is really important if there's a claim made under the purchase agreement. So we're going to be talking about scope and negotiating these overall, but when you're thinking about an indemnification provision and what's fair between both parties, the ultimate thing to think about is really understanding context, which is that indemnifications are protecting you from what-if situations, meaning you don't want these to kill your deal. But at the same time, it is important because it's important how these are handled. With that said, there are statutes of limitations anyways on how long claims can be for any sort of thing. So there's statute of limitations for tax claims, which are generally 7 to 10 years. There's statute of limitations for lawsuits, which are generally 2 to 3 years. It all depends on state law. So that's something to think about, is just remembering context while these things are getting negotiated, that this is what-if scenarios. And even in the event of a what-if scenario, there's other things to think about, like, is this a claim that might be covered by insurance? Is this something that would run out with statutes of limitations anyways? Is this something that we've already covered upside down and backwards elsewhere? So really understanding the practicality of it will help you to navigate the challenges of negotiating indemnification provisions. With that said, let's explain a few of the common terms that you will encounter in indemnification provisions. So first of all is the scope. This is what the indemnification provision will cover. And so that may include breaches of the representations and warranties from the buyer and seller in the purchase agreement. It could be tax liabilities that are pre-closing or post-closing, or it could be third-party claims. So essentially, this can be designed to cover claims between the parties, claims from third parties, claims from taxing authorities or other governmental organizations. So the scope of the indemnification is important, and there may be different treatments for different things, and oftentimes there is. So there's things called fundamental representations and warranties, which is basically like, if these aren't true, this deal is null and void. And so that is generally going to be who owns the business, authority, and due authorization to be able to enter into transaction documents, making sure that all of those consents are received, which most people don't even realize are necessary for a transaction to be valid and binding, and all of those types of organizational representations and warranties as well. So those are fundamentals, and typically they're going to be treated pretty differently, because if the deal were null and void, then there shouldn't be any cap. There's a lot of different treatment in terms of survival and everything, which we'll talk about a little bit later. And then there's also tax. Tax is also generally treated separately because the length of the statute of limitations is so much longer for tax claims. And it's pretty clear generally that most people agree that if it was a tax pre-closing, the seller should be paying for it. If it's tax post-closing, the buyer should be paying for it. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. Okay, now that we have a little bit of a talk about scope, let's also talk about survival. So survival is how long this protection lasts. This is contractual protection that one party is offering another that is intended to be fair. So how long should it last? Now, we're going to be talking about negotiation points from the buyers and sellers and preferences and everything. But of course, based on what I just told you, it makes sense that tax claims would last longer than regular claims, and ultimately the parties are going to find something that's roughly fair. I would say 12 to 24 months are generally the average of where things land. The fair point is like 18 months. By 18 months, you most likely know of any claims that are going to be brought or need to be brought. That's a year and a half out. That's pretty solid. Buy side, I'm always going to be going out asking for more, and sell side, you're always going to be wanting less. And then for tax, you generally want that to be the full statute of limitations because on the whole, that's pretty fair between the parties. And then with respect to other types of claims, you just have to think of what would be fair, what's necessary, what's appropriate, what's covered by insurance, what's not. And then there's things called baskets and caps. So a basket, think of it like a deductible in insurance. That is the threshold that must be met before claims can be made. And so there's things called tipping baskets and non-tipping baskets. And so you have to think of, once that deductible, quote unquote, threshold basket is met, do you want to go back to $0 for recourse? Or do you want to start after that threshold being $0 and then anything after that is collectible? So that's negotiable between the parties. And then there's caps, which is your cap on protection. And they're not altogether uncommon or common. You see them here and there. Most of the time, if there are caps, it's going to be in more sophisticated transactions, sub 5 million. You see them a lot less. But if there is a cap, it should only be with respect to third-party claims, but it wouldn't be with respect to fundamental reps and warranties. So the fairness around all of these is pretty nuanced depending on deal size and deal economics and what you would typically see. So your attorney will be able to guide you. And of course, if you'd like to work with Dean Street Law, you're welcome to apply through the link in the show notes. And then what is the financial protection, and how is there going to be recourse in the event that there are claims? So most of the time, the buyer needs more protection than the seller needs, because this buyer is going to be operating the business post-closing. And so if there is a claim, it's going to be going to them. But if there's something that the buyer needs protection on, that's a great avenue for the seller note to have set off and clawback provisions and everything like that. And then you also may have an escrow holdback. So an escrow holdback is where a certain portion of the purchase price is held in escrow with respect to all or part of the indemnification provision. And that may be for 12 months or 6 months or 18 months, the full time of the indemnification. It really depends on what it is and what it's protecting against. Typically in sub $5 million deals, you're going to see escrow holdbacks more often if there is a known liability. So let's say there's a lawsuit, which in and of itself isn't the worst thing. As long as you know how much the maximum claims are and what the potential liability is, the parties can negotiate having an escrow holdback that would cover the potential liability. If there's known environmental issues and it's known that there needs to be some level of remediation, they would get estimates for the remediation. And of course, that may not cover everything. So you may have a little bit of overage that's included in the escrow holdback. And then that would be held until this matter is resolved for however long. Or you may have a general escrow holdback in more sophisticated transactions where you want to make sure that there's adequate protection. But remember, you can use the seller note to provide protection as well. With that said, you have to think of cash is queen and making sure that you understand what recourse you'll have access to with cash and what you have as already insurance in the business. So while a seller note is great, that would be setting off future liability and cash outlay. Whereas if you have an issue, that may require significant cash on hand, in which case a seller escrow holdback would be helpful and important. So it just depends on the level of risk that there is, the sophistication of the parties, what's being negotiated. If there is a seller note and the escrow holdback, it becomes a huge issue. There's plenty of protection as long as there's insurance in place the seller note may have. So all depends on the party's risk tolerance, but there are plenty of avenues to negotiate all of this. And then we talked about a couple of the different aspects. So a lot of those different key terms are all different things that are going to be negotiated in your indemnification provision. Another aspect is how defense of those claims will be handled and who is going to manage the defense of those claims, and then who is going to be responsible for paying for the defense of those claims. So not only the claims themselves, but the litigation costs, the attorney costs, the fees associated with that, and whether it's attorneys selected by the buyer or the seller or who has a say in that. So all of those defense and control provisions are going to be negotiated as well. And then you also have in your structure and negotiation, what are your exclusions going to be and carve outs. So most of the time, there's also going to be carve-outs so that I'll protect you, except in the event that you acted with willful misconduct, which is when they acted intentionally to do something wrong, in gross negligence, where they didn't intentionally do it, but they should have known that it was such an issue that it is extremely negligent of them to have acted in this way. Or fraud. So gross negligence, willful misconduct, and fraud are generally accepted exclusions for indemnification provisions. And if you're protecting someone else, you should always have those exclusions in there, because if it's their fault, then they should be responsible for it. And that's a pretty typical clause. Now, when you're thinking about if I'm on the buy side, how would I be negotiating it versus if I'm on the sell side, how would I want to be negotiating it? There's different aspects to each. So on the buy side, they want a broad indemnification to protect them as much as possible because they're going into something not sight unseen, but with the seller having such a huge advantage of them. So they want to include breaches of representations and warranties, covenants, all of that. They'll want longer survival periods, and they'll want lower baskets so that there's a lower deductible, quote unquote, to be able to make a claim. And then they'll want higher caps so that they have the maximum amount of protection. And then they may also want an escrow or holdback mechanism as well for easier access to funds if there's an issue post-closing. And then their goal would be to have none or limited influence of the seller in their control over any defense or something like that. So overall, that's what you're going to see a buyer asking for. But just remember that most of the things that you ask for, the opposing counsel will ask to be mutual. So if you're ever asking for something, be prepared for the opposing counsel to ask that it be made mutual, and then be prepared that if you're not willing to accept that, then that's likely not going to be something that's agreed upon by the parties unless there's an outlying reason why it should be atypical or one-sided. And then on the sell side, what they're looking for is a more narrow indemnification obligation with a clear limit to post-closing exposure, shorter survival periods to reduce their long-term liability risks, as well as higher baskets or deductibles and lower caps so that they can minimize their financial risk, knowing that they're selling their baby, this is their one time to get as much as possible, and they want to minimize that exposure as much as possible. Now, in bigger deals, usually $25 million plus, you may also see rep and warranty insurance. But rep and warranty insurance is very, very expensive because you're basically having a whole third party do all of the diligence that both the buyer and the seller did in the deal, and they're underwriting it. So you have the bank underwriting it, you have your lawyers doing due diligence, you're doing due diligence, and then you're going to have a rep and warranty insurance company come in and do a lot of due diligence because they are going to make sure that they cross the D's and dot the I's and feel comfortable ensuring that these representations and warranties are accurate and correct. So that's also part of the reason why, unless you have a CFO, a CMO, HR, it's unlikely that you're going to have all the documentation needed for rep and warranty insurance due diligence, and it's very expensive as well. So while it is a good opportunity, and I've also heard that there are opportunities for rep and warranty insurance that's getting better priced under $25 million, you typically don't see it unless it's a bigger deal. So those are all of the different ways that you will typically see indemnification provisions negotiated at a glance. I will say this is a very complex area that is highly driven by what's market. So if you are buying or selling a business, you absolutely need to have a mergers and acquisitions attorney that is well experienced in this area and is comfortable and knows what's market in the different areas of negotiation, especially indemnification. When you're thinking of what's market, it is drastically different if it is a private equity deal versus a Main Street deal, an ETA deal versus a $5 million deal versus a $25 million deal. And there are so many different nuances to that in terms of negotiating what is market. So while I would love to share more about what's market, I did share a little bit about timelines. You could typically expect it to be 12 at a very bare minimum, and that's really, really low. But typically more around 18, sometimes you get 24. Buyers will ask for 36 months of indemnification for regular claims and 7 years or 10 years, depending on what's applicable for tax claims. And then sellers, of course, are going to want something like 6 to 12 months of indemnification, but hence why we typically land at 18. With respect to caps, I mean, it really depends. Most of the time, there's no caps for fundamental reps and warranties. Sometimes there's caps, but it really, really depends on what the level of sophistication of the parties is and the deal size. What else do we have in terms of general what's market? When you're thinking of the amount of escrow and holdback, you have to think of like what types of claims would not be covered by insurance, and then what would they be? So it's highly dependent on the business and their client base and their contracts that they have. So determining an average escrow or holdback or baskets and caps really depends from business to business and their levels of exposure. So trying to quantify those and understand those and work through that with your attorney is really beneficial. As I said, if you'd like to work with us on your indemnification provisions, we would be happy to help. You can use the link in the show notes to schedule a complimentary consultation with us. And I have to remind you before I wrap up, please be sure to sign up to get the first chapter of my book, join the pre-order list, and order it to support us. It means the absolute world to us. And be sure to also subscribe and leave a 5-star review. That really helps us. I would also love to know, what would you like to see in the next episode? In the meantime, be sure to subscribe, check out Entrepreneurship Through Acquisition, a legal guide to buying a small business, my new book, and I look forward to seeing you in the next episode. Cheers and happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us. And share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal making.